So, a very good morning to you all. Now, let's focus ourselves on this video. Here today, we are going to make a video of law of taxation. And myself is Ashish Kumar Kaushal. I am a student of LLB second year. And let's see how much we can cover in law of taxation. I'm a bit nervous. This is my first video lecture. Let's see how it goes. So here are the contents of the PPT that presentation, and we are going to cover a lot of syllabus according to law of taxation. So let's begin. The contents are Module One: History of Tax Law in India. We will cover a history of tax law in India, the constitutional provisions relating to taxation, and the nature and scope of taxation is will be of tax will be covered, and particularly in module 1 we will cover some definitions, the main important definitions of tax. In module 2 we shall cover income tax and residential status rules, section 6, tax liability, exemptions, deductions related to individual expenses and income, rebate, deemed income, and clubbing of income. So before going further, let me tell you one thing, that our focus will be on case law basis, the judgments basis, because the Supreme Court has uh, valuably interpreted the statute in a very good way, and we shall not go beyond this point. So I recommend you should clearly check the video, and content is up to the mark according to me. So we will also cover carried forward and set of losses, heads of income, where there are very five heads of income are there in India, that is income from salary, house, property, business and profession, capital gains and other sources. So in module 2, we shall also cover how to calculate gross total and taxable income, tax rebate and computation of tax liability. The taxation in cases of mergers and acquisition where the two companies get merges or partnership liabilities. Tax collection and deduction at source, TDS and advanced tax will also be covered. In module 3, assessment procedure, how we calculate the assessments of a particular financial year. Types of assessment will also be covered, and advanced rulings, faceless assessments, and e-assessments. So in module 4, goods and service tax will be covered, and basically I am a student of Punjab University, so we shall cover Punjab State Tax on Profession, Trade, Calling and Employment Acts of 2018. 2018 is the latest act. I think it will cover a lot of part on taxation. So these are the recommended books. I recommend you to kindly go through these books. These are highly good books. Taxman books are also very good, like K.N. Chaturvedi, Interpretation of Taxing Statutes. So I will be focusing myself on Kanga and Palkiwala's The Law and Practice on Income Tax, LexisNexis. And the Bare Act language will be covered, as we will see in the future of this presentation. So let's begin with the history of taxation law in India. So as we all know, the taxation law is there are two taxation laws were present in India. One was in 1922, and other we after independent India we made our own Income Tax Act 1961. So the Law Commission's 12th report 1958 and Direct Taxes Administration Inquiry Report 1959 are the very basics of Income Tax Act 1961, which replaced the 1922 Act of Indian Income Tax Act, and it worked for 40 years. So what was the need to replace this act? According to is the 40 year of operations of Income Tax Act of 1922 has been amended more than 1,000 times. So in that case, the original purpose of statute was its simplicity and stability, which made it the amendments made it more highly complex. So it really resulted in a wholly frustrated state. So the history of Income Tax Act continues. So let's begin with Income Tax Act started. Income Tax Act was first introduced in 1860 during the British India tenure by Sir James Wilson. What was the need? Because the British India faced very financial difficulties after the rouse of the mutiny of 1857, and the law was in force for about 5 years. I think we should get a table on this. You can note it down. It's very easy. It's not so difficult. Thereafter, during 1867, the license tax was imposed on trade and profession only, and 1868 a new certificate tax, which was similar to the license tax, was also introduced. However, during 1869, a regular income tax was announced, but was again abolished after 5 years as the financial situation has improved by then. So in 1877, once again, the license tax was again introduced, which included land cess also there. So in addition to this, the local legislations were also introduced in presidency towns. So in 1886, a legislation for the first time, the legislation of levy of tax was introduced. In 1918, it was reintroduced with many changes to overcome inequalities of previous acts, and six heads of taxation were introduced for the first time. So during the British India tenure, during the 1918 Act, there were six heads of taxation. But after that, at present scenario, we have only five heads of taxation, which shall be covered in the ongoing video lectures. So after the recommendation of All India Income Tax Committee, the Income Tax Act of 1922 was introduced, which was then replaced by the present Income Tax Act 1961. So in 1961 Act received the presidential assent on September 13th, 1961, which came in force from April 1st, 1962. So it was based on the recommendation of the Law Commission's 12th report and Direct Taxes Administration Inquiry report. It replaced the Income Tax Act of 1922, which has remained in operation for 40 years. So I don't know, but I think we should have a knowledge of these examples that I am taking. And the date before 2021 will be explained in the future upcoming videos. So the example is like we have a special economic zones, which was to the income tax was exempted. Various economic zones were exempted from income tax for a continuous period of 10 years. So without any concern of sanctity of the legislative promise, the Finance Act 2011 was amended, and special economic zones were levied from minimum alternate tax on units on special economic zones. So suppose we have a company that is working under special economic zones, the tax was levied there. The other regrettable feature is reported resort to retrospective amendments to nullify any adverse decision of income tax appellate tribunal, high courts, and the Supreme Courts. So in that case, suppose if person wins a case till the Supreme Court and the legislation, if succeeded, if the person succeeded in getting the decision in his favor, the legislation can amend it with the retrospective effect and making that Supreme Court decision null and void. So there was a concern about this. So it's before 2021. Let's see in the future lectures what happens in this. So in slide 9, before previous slide, we talked about history of income tax, five heads. So we will further see that these five heads are which five heads, and I recommend you to please have some patience. So let's we will start with Income Tax Act and the Constitution of India. So it can be said that we are talking about validity of Income Tax Act, legality of Income Tax Act, and from the judgments of the Supreme Courts and High Courts, so, and Constitution of India. So in New Delhi Municipal Committee versus State of Punjab. That's 1997. All the precise accuracy has been taken, so that the citations are to the mark, up to the mark. But if there is any ambiguity, obviously we are studying interpretation of statutes. So if there is any ambiguity, you should comment in the comment section, and please, it's highly recommend, please cross verify and go through these judgments, as these are very valuable judgments. And especially the India Cements Limited versus State of Tamil Nadu. I hope I am pronouncing it correct. So it was held in the New Delhi Municipal Committee. It was held that the power to tax is an incident of sovereignty. And further, in Commissioner of Income Tax versus Harijan Nigam, it was held that since the Constitution of India is the supreme law of land, and all other laws, including the Income Tax Act, are subordinate to the Constitution and must be read and interpreted in light of the Constitution provisions. So the Constitution of India is the supreme body which authorizes the legislation to make and amend the laws in India. Obviously, the lex loci laws that are applicable in the land and territorial of India, as present as per now. So, and further, in India Cements Limited, a seven-judge bench of Supreme Court observed. I have correctly, I hope that I have written it correctly. Observed. So the word observed is that means it is a obiter dicta, not ratio decidendi. When the ratio decidendi is to be said, it is held, but when observed is written, it is obiter dicta. So observe that constitution is the mechanism under which laws are to be made, and not merely an act which declares what law is to be. So the interpretation is of this line is very get agar if we use simple interpretation, we can understand this line in a very good way. So one of the most important provision in constitution relating to tax is article 265, which provides that who shall levy or collect the tax. Only the authority of the law given by article 265 of Indian Constitution of India. Therefore, any other authority, even an executive order, is not authorized to make, to levy or collect any kind of tax. So on there, not only the levy but also the collection of a tax must be under the authority of some law. So this is the direct language of Article 265 in Constitution of India. The taxes are not to be imposed by not to be taxes not to be imposed save by authority of law. No tax shall be levied or collected except by authority of law. So the definition of law is precisely given in Ghulam Hussain versus State of Rajasthan, AIR 1963. And in this article, the law means that law enacted by a competent legislature and cannot include an executive order. See, I told you in the previous slide that executive order is not a specific body to levy or collect the tax, or a rule without express statutory authority or a custom. Thus, any act of the state that seeks to impose a tax must come from the legislative authority only. So, without legislative authority, this tax shall be declared void. So, in Shri Mahalakshmi, in Krishi Utpadan versus Shri Mahalakshmi, a rule without express statutory authority or custom. In the previous case, Ghulam Hussain versus State of Rajasthan, we have written a line here: a rule without express statutory authority or a custom. These were interpreted in the Supreme Court judgment of Krishi Utpadan versus Shri Mahalakshmi, 1995. So, taxation In the state of West Bengal versus Subodh Gopal Bose, All India Record, All India Reporter, 1954. So the taxation is an independent power of state, and there is no fundamental right to be immune from taxation. So the citizens of India has no fundamental right to be immune from taxation. So we shall further cover the Article 13.3, subclause A, which it defines the law. The law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. This includes a taxing statute. It also includes statutory orders and orders made in exercise of a power conferred by a statutory rules. It was interpreted in BD Supply Corporation versus Union of India, AIR 1956. So, how to check the validity of a statute and approach of the court. So, these were the points that were discussed in 2006 in the case of Arun Kumar versus Union of India. So, first we have to, if you have to check the validity, first the burden of proof. Who shall have the burden of proof? The person who attacks a statute to prove that it's transgress to the constitutional principles. That person will have the burden of proof. Or otherwise, we can say that law is always presumed to be valid unless and until it is objected by somebody. And the objected person, the person who objects the law, will be responsible to prove it that how it is to be declared invalid. Aids to interpretation. So in this judgment, the different kinds of aids were taken, and court may consider, the word may is there. The court may consider external factors such as matters of common knowledge, reports, committee or law commission reports, preamble of the act, history of the times, the object of legislation. The third point here is presumption of legislative competence. It is presumed that legislature understands the needs of the people, that any classification or discrimination created by law is based on adequate grounds, and that any classification or discrimination created by law is based on adequate grounds. So, liberal interpretation to save the law. If the liberal interpretation makes a law, justifies a law, then it shall be declared constitutional. Constitutional conformity. Even if a provision confers wide powers, it can be construed in a way that confines the exercise of those powers within the constitutional limits. So, transmitting the inarticulate. So, a statute is silent or unclear on a point. The court will attempt to interpret in a way that leans towards its constitutionality, as long as it stays within the material of which the law is woven. So, doctrine of reading now. This doctrine is very much important for checking the validity of a law in India, and its main purpose is it's a tool used to uphold the validity of a law by interpreting it narrowly or in a restricted manner to bring it within constitutional limits. So when is it is to be applied and when not it is to be applied. So when it is applied, we have three conditions: when the law is silent, when when the statute is silent, ambiguous, and allows more than one interpretation. So when it does not apply, limitation should be there. Limitation is also there of doctrine of reading out. When a statute clearly says that it it is clear, when a language used in a statute is clear and expressive, this doctrine of reading down cannot be used. So The court must interpret the law plainly and either declare it intra vires within the powers or ultra vires beyond the power of statutory body who made the statute. So test for reasonable classification. This is Article 14 of the Article 14 in the Constitution of India guarantees equality before law and equal protection of law. So what are the two major tests that is to be taken in Article 14? So in Muhammad Sujad Ali versus Union of India, the citation is not given here. Let me. Okay, I will post it in a comment section. It prohibits class legislation but permits reasonable classification. It should be reasonable enough. So similarly situated person should be treated equally. Suppose in taxation we say that we have made a provision where women are exempted from a tax law. Obviously, it's an assumption. It's a hypothetical situation. It's not a true situation. So in that case, if women are declared, so that can be a reasonable classification under Article 14 because all the women are similarly situated persons. And further, it was also held in Muhammad Sujat Ali. Similarity must be tested with reference to object and purpose of the law. Classification must include all persons similarly situated in relation to that purpose. So if we consider it like suppose I am earning 5 rupees and my friend is also earning 5 rupees, then the law should be precise and accurate for both of us. But if I am earning 5 rupees and my friend is earning 100 rupees, so the tax provisions shall differentiate from between two. This is similar situation persons should be treated equally. So similarity is not equal to factual similarity, but similarity is equal to similarity in relation to legislative objective. So and compared to the taxation law, the financial income is governing the basic principles of classification. So it permits reasonable classification. The twofold test of twin conditions of Article 14, intelligible differentia and rational nexus. So differentia plus nexus, if both are there, not either one, both should cover, then only it shall be a valid classification. So the in Bharat Hari Singhania case 1994, citation is not covered here also. And the greater latitude and greater play in the joints. Play in the joints allows the legislature to get a greater flexibility of the law, to make a greater flexibility in the law. So validity is always presumed that the law is constitutional. And policy matters. Courts don't question wisdom of who to tax or exempt. Under classification in tax laws. Under classification per se is not fatal. Legislation has the right to identify specific persons to tax, like special economic zones and other persons. Courts recognize real difficulties in legislative drafting. Arguments like companies left out or non residents excluded do not automatically invalidate the law. So, this was given in Rajan Bhatia versus CBDT 2019. So, valid basis for taxation. The ability to pay how much I am earning. That means if I am earning 100 rupees and I am capable of paying 1 rupee or 2 rupee or 5 rupees as a tax, graduate tax rates accordingly. So, tax rates are decided on the ability to pay and nature of entity. If the public sector or private sector can be taxed differently. So, Sashikant Lakshman Kale versus Union of India 1990 case. And residency, residence versus non-residence can also be taxed differently. So purpose of entity, religious or charitable trust versus private landlords. It was given in Christ the King Cathedral versus John Enscherill 2001 case. So creating of subclasses within a text must require a valid reason. Within homogeneous groups requires valid reason. Otherwise, the statute may be declared as arbitrary and unfair. So it was given in CAG versus Kamlesh Vadilal Mehta 2003 case. Only partnership firms of CAs made eligible, excluding proprietary firms, for enrollment on its panel of auditors for the job, and to the same effect it was advertised. So there was partnership firms in which the CAs were to be hired. So ex- they excluded the proprietary firms. They included only the partnership firms. So it was declared arbitrary and unfair. So court held that this is no valid reason for subclassification. Extent of laws made by Parliament. Article 245 subclause 1, which talks about territorial nexus. So there is a general principle applicable to income tax that either the source from which the taxable income is derived should be within the territorial limits of the country imposing the tax, or the person whose income is to be taxed should be resident there. So two conditions are here. In Dawson versus IRC case 1988, it's a European Union case. So in that, two conditions are met. Source should come from that country, or a person should be resident of that country. So its example is also seen in Vodafone Idea Limited versus Deputy DIT 2023 case. It's Karnataka High Court judgment. I don't know if further they have gone or not, but as of my knowledge, the court interpreted and it has been again reiterated that income tax authorities in India do not have jurisdiction to bring to tax income arising from extraterritorial source, that is outside the India, in respect of business carried on by foreign companies outside India. So it is also further discussed in section 1 subsection 2 of the Income Tax Act. So Article 246, which clearly states that Parliament has plenary powers to make laws for the Union territories on all matters. So Income Tax Act 1961 is extended to Union territory with such modification as it fits. Thus, President can by regulation made under Article 240 of the Constitution of India extend Income Tax Act 1961 to the territory with such modification as he thinks fit. A proper care has been taken of the articles. If there is any ambiguity regarding the articles, the comment section should be taken into consideration, and obviously all the comments are to be accepted and will be taken seriously. In such a case, a proviso to Article 246 subclause 1 is also there, which does not act as a fetter on the general power of President to make regulations for UTs. While lone legislature for the territory is brought into existence and proviso does not enact, the power of President is confined to making laws with respect to the matters enumerated in state list and concurrent list. So TM Kanyan versus Income Tax Officer 1968, it was held. The proviso of the 246 subclause 1 of Constitution of India was interpreted in this judgment. So what is Article 366 now? Article 366 is obviously a definition clause in Constitution of India. So 366 sub clause 29 defines tax on income. So which includes a tax in the nature of excess profit tax. 366(1) defines agricultural income. Although the agricultural income is already highly precisely defined in the statute, like Income Tax Act, we shall study further in the upcoming slides, upcoming video lectures. So agricultural income here is defined as for the purpose of enactment relating to Indian income tax. In 1961, Section 21A defines agricultural income. So, as per Article 366(6), corporation tax means tax on income so far as that tax is payable by companies and is a tax in the case of which the following conditions are fulfilled. That is not chargeable in respect of agricultural income. No deduction in respect of tax paid by the companies is by any enactment which may apply to the tax authorized to be made from dividends payable by the companies to individuals. That no provision exists from taking the tax so paid into account in computing for purposes of Indian income tax, the total income of individuals receiving such dividends